We're on the record. The Maryland Public Service Commission will come to order in case number 9647. The matter involving Maryland Office of People's Counsel versus Sunsea Energy, LLC. Today's status conference was noticed on December 14th, 2020 in order 89677. This conference follows our hearing on October 7th, 2020, as supplemented by an order dated October 9th, 2020. The scope of today's status conference was outlined in the December 14th order, and the purpose today is to review the compliance activities of Sunsea Energy since our evidentiary hearing, as well as to determine a penalty amount if appropriate. Today is not an evidentiary trial type hearing. The parties may have witnesses that the commissioners may inquire of. However, there will be no direct examination or cross-examination of the witnesses. However, counsel may sponsor the written testimony that was filed in the record, and the sponsoring counsel will be able to authenticate that testimony and introduce it through their respective witness. At this point, we'll take appearances by counsel, beginning with counsel for commission staff.
Good morning, Your Honors. Peter Wolson on behalf of the staff.
Maryland Office of People's Counsel.
Good morning, Your Honor. Patrick O'Loughlin from Maryland OPC. I'm joined by David Lapp, People's Counsel.
Morning, Mr. O'Loughlin. Good morning, People's Counsel Lapp.
Good morning.
We'll now next turn to Sunsea Energy, LLC.
Good morning, Mr. Chairman and Commissioners. James McGee with the Law Office of Robert Castro on behalf of Sunsea Energy, LLC. And with me today is Jacob Adigwe, the CEO of Sunsea Energy.
Thank you, Mr. McGee. Are there any other individuals that wish to enter an appearance today? Hearing none, we'll move to the substance of today's status conference. We've received a number of filings from the parties over the past few weeks. It's also been brought to our attention that we have a discovery dispute that, as I understand, has not been resolved prior to today's status conference, although the commission did issue an expedited order on Monday, January 25th. Mr. McGee, I'll start with you. What's the status of these outstanding data requests?
Mr. Chairman, they have been responded to, so I don't believe that there is any ongoing dispute any longer.
Thank you. Mr. O'Loughlin, do you concur?
I do, Your Honor.
Are there any other preliminary matters that we have or discovery-related matters to address before we begin today? Okay, seeing none, I'll allow the parties to briefly recite their positions based on the commission's order and the purpose outlined in the December 14th notice. Mr. Wolson, on behalf of staff, I'll allow you to proceed.
Your Honor, staff's position is that as far as we can tell, Sunsea has fulfilled its obligations under the Commission's orders to date. However, still outstanding is the question of a civil penalty and the revocation of the license. And we continue to recommend that Sunsea be given a substantial civil penalty up to $500,000, and we also believe that revocation of Sunsea's license is in order.
Thank you, Mr. Wolson. What I'll do next is turn to OPC, and then Sunsea Energy, and then commissioners will inquire of the parties and of the witnesses. Mr. Wilson, at this time, would you like to get in the testimony of your witness? Although I don't see Mr. Mosier here.
He was here.
Okay. Well, we'll see. We'll see if he comes back.
Okay. Yeah, I don't see him either.
Okay. Counsel for Office of People's Counsel.
Good morning, Chairman Stanek, commissioners. I'm David Lapp for the Office of People's Counsel. I was going to say a few words and then turn it over to Assistant People's Counsel, Mr. O'Laughlin. This case against Sunsea Energy is similar to others before the PSC and others that are likely to come in the future. There are cases involving patterns of unlawful practice that include numerous violations of Maryland consumer protection statutes and commission regulations. I wanted to focus first on two main defenses that Sunsea Energy has made in this case. Both appear to be efforts to establish a mitigating factor as the commission formulates its remedies. Essentially, their pleas for mercy. The first one is that Sunsea was not fully aware or misunderstood Maryland's consumer protection provisions. It was confused or had a misunderstanding of the laws. Of course, ignorance of the law is not an excuse to violating the law. That's especially the case here, where we have a highly regulated area of law. Retail suppliers need to know the law. They need to be held accountable for knowing the law. They probably do know the law, but the commission shouldn't give this defense any leeway. The second defense is what I'm calling the rogue vendor excuse. That is, that it was the retail supplier's vendor that broke the law, not the retail supplier itself, and that should lessen or somehow affect the relief or the remedy granted here. If I can deviate for a moment, this reminds me, as you know, I'm new in the office, and so when I first heard about this, it reminded me of my 10 years at the AG's office working on tobacco enforcement. There, I litigated with big tobacco manufacturers, but also my unit was responsible for enforcing against small cigarette manufacturers a requirement that they deposit money every year into an escrow account to cover the health consequences of the cigarettes that they sold in Maryland. In the early years, these small cigarette manufacturers were hardly compliant at all, very low levels of compliance. We sued them and enforced against them and got judgments, often default judgments in court, and then only to have these companies turn around and form a new company and sell the same cigarette brands through a new company. And some of them would change companies every year. And so essentially we were playing whack-a-mole. We'd have to start all over every time. If you allow this rogue vendor excuse, I'm afraid you'll have the same problem, or we will have the same problem in Maryland as we did with tobacco. We'll be playing whack-a-mole because as a retail supplier will use one vendor. Oh, that was a rogue vendor. We found the new one. And it'll be an infinite circle. In tobacco, we close that gap in the law essentially by having a license or certification requirement before the cigarette seller could sell in the state. The PSC already has that statute. It's the licensing statute. All you need to do is ensure that those retail suppliers are 100% responsible for the actions of their vendors. You don't want to play whack-a-mole. The commission should unequivocally reject both the ignorance or misunderstanding of law and the rogue vendor defenses. Just one more quick comment before I turn it over to Mr. O'Laughlin. I want to encourage the commission to act very forcefully in these early cases against retail suppliers in order to defer future violators. The depth of this supplier's misconduct was largely identified because they had the unfortunate mistake for them of soliciting Deputy People's Counsel. I understand there's approximately 50 retail suppliers in each of the utility service territories. You can be sure there are other suppliers out there that have not been identified that are also violating these consumer protection statutes. These are resource-intensive cases. OPC and staff have limited resources, so strong deterrence is required. The Commission's response in this case should reflect the likelihood that many supplier deceptive activities may not be caught. And it should send a strong message that it won't tolerate anti-consumer behavior. With that, I want to turn it over to Mr. O'Laughlin to discuss more of the details of this case. Thank you.
Mr. Chairman, Commissioners, good morning. Just wanted to start off by pointing out that in their filings showing their attempts at compliance, Sunsea identified about 1,400 customers that they returned to SOS that needed to be refunded. 163 of them did not have any sort of flow of electricity or gas, so that left us with 1,258 checks sent out. And we found out just yesterday that only 334 of those checks have been cashed to date. And the total amount sent was said to be $66,000 and $66,675.91. Now, we didn't have a whole lot of opportunity to be able to cross-check each and every one of these checks to ensure that these were the proper amounts, but we did have the 30 CAD files in this case to check against. In looking at them, one of them got less than the correct amount as admitted by Sunsea. One of these customers got double paid. And in looking at the amount, the total amount refunded, to our eyes, for lack of better term, it looks suspiciously slim, especially when you take into account the kilowatt hour rate that they were charging of sometimes up to 18 or 19 cents per kilowatt hour, well and above what standard offer service rates are. Now, as Mr. Lapp noted, our resources to perform a proper audit of this of these refunds just they're not present for OPC or for staff. And I acknowledge no one wants this litigation to be protracted. It would be great if we could be done with this today, but I don't believe and I don't know that there has been proper compliance when in a small batch of 30 of these cases, we've already seen a number of discrepancies. And the most important thing is to ensure that there's proper compliance and that the defrauded customers are properly refunded. An outside audit would accomplish this, and the Commission could order Sunsea to undergo an audit by an outside company to be approved by the Commission. And this would set a precedent for the upcoming supplier matters that this Commission takes these matters very seriously and expects strict compliance with its orders. However, if the Commission is not of the opinion of ordering an outside audit in this case, given the discrepancies, given the fact that in testimony, Sunsea was deemed to be not credible and indeed seemed, to my eyes, trying to escape blame for these matters, OPC is not able to reduce its recommendation of a $2.5 million penalty in this matter. Thank you.
Thank you, Mr. O'Laughlin. I see that staff witness Kevin Mosier is back with us. Mr. Wilson, would you like to authenticate the testimony?
Yes, I would, Your Honor. Thank you. Can we call staff witness Kevin Mosier, please?
Mr. Mosier, could you please raise your right hand?
Mr. Mosier, do you solemnly swear under the penalties of perjury that the statements made in the matter today are the truth, the whole truth, and nothing but the truth?
I do.
Mr. Mosier, could you state your position with the Commission and your business address, please?
I'm the Assistant Director of the Energy Analysis and Planning Division, and my address is 6 St. Paul Street, Baltimore, Maryland, 21230.
Okay, and in your capacity with the commission, did you prepare and cause to be filed direct testimony dated January 20th, 2021 as mail log 233392?
Yes,
And did this direct testimony also include exhibits with it?
it did.
And is this testimony true and correct?
It is.
Your Honor, with that, I would ask that Mr. Mosier's direct testimony be marked as Staff Exhibit 1, and I would move it into the record as Staff Exhibit 1.
It is so marked as Staff Exhibit 1. Is there any objection?
No, Your Honor.
Thank you. The staff exhibit is moved into evidence. We'll next proceed to Mr. McGee and Sunsea Energy LLC.
Thank you, Your Honor. At the conclusion of the hearing on October 7th, 2020, the Commission found that Sunsea Energy's compliance with the refund process will factor into the consideration of any penalty amount that may be considered and calculated at a later date, which is why we're here today. So as the PSC has seen with these compliance filings made by Sunsea in this docket, and also referenced in the direct testimony of Jacob Adigwe, Sunsea has complied with the Commission's order, both from the bench and also the October 9th order. Sunsea's position is that no additional penalty is warranted. Sunsea has refunded over $66,000 to customers pursuant to the Commission's order. And so that is like a direct penalty that went directly to those customers that the Commission found were victims in this case. In addition, you may recall that Sunsea voluntarily ceased enrolling new customers back in May, which was even before the complaint was filed with the Commission. It was basically right after OPC had contacted my client and informed them of the issues that occurred with Mr. Fields. Also, at the October hearing, Sunsea pledged and does so here again that as a penalty, it will not enroll any customers via telephone any longer, which really goes to the heart of the case and the penalty that directly addresses the violations. So as People's Counsel Lapp indicated, he was afraid of some type of whack-a-mole process where if there's a new company that was formed, maybe Sunsea would end up as a new supplier. But that won't happen because the Commission reviews all of the applications, and you'll be able to guard against that. In the position about whack-a-mole relating to different agents, rogue agents, that's not going to be an issue here either if the Commission adopts Sunsea's recommended penalty of not allowing them to enroll customers via telephone. It's impossible to have a telephone violation if you're not going to solicit or enroll any customers via telephone. So we think that's a substantial penalty. We think that does send a strong message to not only Sunsea, but other retail suppliers that the Commission does take these type of violations seriously. And the Commission is not allowing this type of activity to go forward because they're enforcing a penalty of you cannot enroll customers via telephone. So we think that's a very strong but appropriate response in this case. To some of the arguments that Mr. O'Loughlin was stating, the Commission had required Sunsea to send the refund checks to customers that were affected and also to send an accounting of those refund checks. And that's what we've done. And People's Counsel and staff and also the Commission have that. There are about 1,400 or so Excel spreadsheets that were included that shows exactly how Sunsea has derived the calculation of each refund. So you don't have to take Mr. Adigwe's word for it or anything you see on paper how this was calculated. And to the comment about the number of checks that were cashed, 334, that's as of Monday. And from what my client says, they continue to roll in every day. That'll happen. People get checks, and it takes them some time to ultimately cash it. So I don't think that's a unreasonable thing. And I did confer briefly with my client just now, and they are willing to, as a condition to continue to have a license, they will file quarterly reports with the Commission that updates the number of checks that were cashed so that the Commission knows that the penalty amount and the refund amount really did go to these customers. That's all for my opening, and I would like to move in the testimony of Mr. Adigwe.
You may do that.
Thank you. Mr. Adigwe, if you could come on the screen and go off mute, please.
Adigwe, if you could please raise your right hand.
Mr. Adigwe, do you solemnly swear under the penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes.
McGee, you may proceed.
Thank you. And Mr. Adigwe, can you please state your full name and business address, please?
My name is Jacob Adigwe, 1930 Moulton Pike in Cherry Hill, New Jersey.
And what company are you testifying on behalf of today?
Sunsea Energy LLC.
And what is your title?
President.
Do you have in front of you a document titled Direct Testimony of Jacob Adigwe on behalf of Sunsea Energy LLC, dated January 20th, 2021, which consists of 8 pages, including a cover page, plus 3 exhibits totaling 17 additional pages?
1 sec, let me pull that up again.
And while he's doing that, Your Honor, would you like this collectively marked as Sunsea 1, or do you want the exhibits to his testimony broken apart as separate exhibits?
Could address this collectively as one exhibit.
Okay, thank you. So
Yes,
do you
I
have that in front of you now, Mr. Adigwe?
Yes, I do.
Okay, so with that, Your Honors, I would like to mark this as Sunsea Energy Exhibit Number 1.
So marked.
Mr. Adigwe, was this direct testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any changes or corrections to this testimony?
None.
So if I asked you the same questions today, would your answers be the same?
Yes, it will.
Are these answers true and correct to the best of your knowledge, information, and belief?
Yes, it is.
With that, Your Honor, I would like to move Sunsea Exhibit Number 1 into evidence.
Are there any objections?
No objection.
Hearing none, Sunsea Exhibit Number 1 is moved into evidence. At this point, commissioners will have the opportunity to inquire of counsel and the witnesses. I will begin, and I'll begin with the staff witness, Mr. Mosier.
Yes.
Mr. Mosier, in reviewing your testimony that was filed last week, you alleged that the rates being advertised by Sunsea Energy on their website are not truly competitive rates. Can you please elaborate?
Well, in reviewing other rates, the supplier rates generally range from the 8 cents per kilowatt hour to around 12 cents, and the Sunsea rates were as high as I think they had a rate of 17.9 cents that they charged one more of their customers. And then I think even the current rates on our website are, again, I think either 13.9 or 14.9 cents.
Based on your experience, would you find these to be non-competitive rates?
I most certainly would. It's hard pressed for me to believe a customer would sign up for a rate that's that much higher than alternatives.
Is it your opinion that marketing these rates as competitive rates is deceptive?
I believe it is.
Mr. Mosier, moving on, in your testimony, you stated that according to the PSC's Consumer Affairs Division, a complaint has been filed against Sunsea since we last met on October 7th, 2020. Can you elaborate as to that complaint?
Yes, just one moment. Yes, there was a complaint number 102-034-7402W was filed against Sunsea on October 13th, 2020, and this complaint alleged misrepresentations.
Do you have any other details regarding this complaint?
I do not.
Thank you, Mr. Mosier. I'm going to move on to the witness for Sunsea Energy LLC. Is the witness available?
Yes, I'm here.
Thank you. Mr. Adigwe, in your written testimony that was filed on January 20th, you stated that you've not enrolled any new customers since May of 2020. Is that correct?
That is correct.
And since the commission's bench order on October 7th, 2020, it's your testimony that you have not marketed, solicited, or enrolled customers in the state of Maryland?
Yes.
According to your testimony on October 7th, you still operate in 4 additional states. Is that correct?
That is correct.
Approximately how many customers did you drop in response to the commission's bench order on October 7th?
That were still active with us. It was about 8,000.
You said 1,000?
Yes.
And these were customers that were enrolled via telephone. Is that correct?
Correct. Yes.
After those 1,000 customers were returned to standard offer utility service, how many customers remained on your books?
Currently, there is none in the state. We have 0 customers left in the state.
Let me inquire further on that, Mr. Adigwe. The commission did not require you to return any customer solicited via door-to-door solicitations. Where did all of those customers go?
We've not been selling in the state for going, for about 9 months now, 8 months now. All right, and attrition, and we did a mass informing the customer of their right to opt out based on the letters that we sent out. All right, so after looking at there were only a few customers left, we reached out to the customer and returned all our customer back to the to SOS, back to the utilities. We like to start fresh in this state because I've been so worried about this case. I want it over. All right, and currently there is none in the states. We didn't get.
Mr. Adigwe, so that I have this entirely crystal clear, you currently have a total of 0 customers in the state of Maryland.
Yes, we do.
And you've returned all of your customers that were solicited via door-to-door solicitation to standard offer service.
Yes, we did.
Mr. Adigwe, did you receive any complaints from Sunsea customers in Maryland after the commission's determinations on October 7th, 2020?
Speaking to October 7th, it looks like we got one more customer by the name Terra Major. All right, and yes, we got one customer that was enrolled through telesales. Yes. Mm-hmm.
Is that the same customer complaint, without stating the customer's name, is that the same customer complaint that the staff witness referred to a few minutes ago?
I guess so, yes. As we just received the closing letter, 2 or 3 days ago. All right. And normally once we get the closing letter, that's when it actually makes it to my desk. But that's about it.
In your testimony, at the very end, you stated that you've made a number of changes to your office in respect to personnel. You stated that Ms. Dorothy Stone and Mr. Ebre Good Luck
Mm-hmm.
are now on staff. Can you please elaborate as to their roles on why they were hired?
You know, in terms of compliance issue that was brought to my attention, you know, I did an internal check, and you know, I'm basically find out, okay, even based on telesale, you know, inbound, why is it that we were not informed that, you know, by our team that a wet signature is still required? So I found that, you know, I got into the struggle because of some of the people that I had that were working for me, basically. So losing all our investments in the state of Maryland, they had to go. And I had to, you know, then we hired, you know, someone else to replace these folks. It was an internal decision, and I was just not happy because of, you know, in every state we make sure we comply by whatever, you know, the rules and regulation are. And, you know, what was brought to my attention by the OPC indicated that no matter what, as far as it's telephonic, there was still there still needed to be a signed contract. And my team was saying something else, that it's not required, you know, that it's not required. And I basically nailed the main, you know, advisor on this issue. And, you know, so as to make sure I'm not exposed in the future.
On October 7th, you testified that Romaine Reed was your vice president. Is Mr. Reed still your vice president?
No.
Do you have any other vice presidents aside from Mr. Goodluck?
No.
On October 7th, you testified that Miss Dorothy Stone was your compliance manager. She is still your compliance manager?
Dorothy Stone is still, yes.
And operations continue out of your office in Cherry Hill, New Jersey?
Yes.
We discussed your staffing levels in October. How many staff are currently in the Cherry Hill office?
About 15. We're still a small, you know, ESCO, but go ahead.
You operate in 5 states, though, correct?
Yes, we are.
You would consider that to be a small ESCO?
Yes, because of we're growing ESCO.
I'm looking at 2 of your letters on compliance that you worked on with the cooperation of Staff and People's Counsel. One of them is dated October 16th. One of them is dated November 6th of 2020. Both to the customers you were returning to SOS and to the remaining customers, which we now understand you have none. On this letterhead, you have an office in Clementon, New Jersey. What office is that?
Yes, that's our first office. 1451. What's it called again? Clementon Road. No. In Clementon, New Jersey. That's our first office before we moved to Cherry Hill.
Yeah. Do you know the address of your first office?
Okay. Yeah, 1451 Choose Landing Road, Suite 100, Clementon, New Jersey.
And you're saying that's your first office? Is that still an office of Sunsea Energy?
No, we moved to 1930 Moulton Pike, Suite N73 in Cherry Hill, New Jersey. All our mails, we get all our mails, you know, forwarded as well. If there is any old ones to go into our old address. Go ahead.
When did that move occur?
I will say this May of 2020. I would say first quarter of 2020. I can't recall when. I can't recall. It wasn't in the summer. It wasn't in the winter. Yeah. I can't remember the exact month right now, but I know it wasn't a winner of 2020.
Mr. Digwe, are you consulting with somebody off camera for answers?
Yes, I do have some of my assistants here.
Okay. Counsel, can you instruct your witness?
Sure, Mr. Adigwe, these questions are of you and they are not of anyone with you. So if you don't know the answer to a certain question, then tell the commission that you don't know or don't recall. If you do know the
Okay.
answer, please go ahead and give the answer, but do not consult with anyone else.
All right. Thank you very much.
Mr. Adigwe, your response raises additional questions of me. You stated that you moved from Clementon to Cherry Hill back in first quarter of 2020. Why, on your compliance letters dated October 16, 2020 and November 6, 2020, which I have here, are you using an address that the company no longer operates from?
You see that I forgot to update the address there. But any mail sent there still get forwarded to us by post office. All right, but we've updated staff and in all the states, informing them that our current address is 1930. All right, in Moulton Pike. I probably didn't catch that. That's one of our letterheads, our hood letterheads, and probably that has not yet been updated. That's all.
Mr. Digwe, do you not have staff to assist you with complying with these commission directives, or do you do this by yourself?
No, we do have staff that assist. Yes.
You've heard from Counsel O'Laughlin with OPC that upon a spot check of just 30 of your customer accounts, they found a number of errors, leading OPC to question whether or not you accurately complied with commission directives with respect to the other 1,200 accounts and change. I'd like you to walk me through your compliance efforts in making refunds to customers from the time you received the commission order to the time those checks were placed in the mail. So if you could just walk me through step by step how you actually complied with the commission's October 7th order with respect to refunds. I'm only talking about refunds.
Once we received the order, all right, the first thing we had to do was manually do the re-rate calculation for each customer, which with both the staff and OPC does have units for each customers, if it's gas and electric or just gas. All right, we did a re-rate calculation, compare it, of our rate and that of the utility rate. All right, the SOS rate. All right, and we gave them the evidence. They currently have the re-rate calculation, which they can easily verify through the utility. All right, we did the re-rate calculation, table the total, then I dispatched it to the accounting team to print out the checks. For the customer, they were, a little bit over 1,200 checks. That took basically weeks to get months actually to get imputed. The immediately once we had to also do massively what's it called? Okay, pertaining to the check you referred. All right, and we had to also do a mass printing of the letter which was required to go out to each customer. All right, so once they were all produced, before they were all massively mailed out to the customer.
Can you give us a little more insight, please, with respect to the distribution of these checks? How, as I, in my seat as a commissioner, how do I receive confirmation that each of these checks were actually dropped in the mail?
By seeing the check, the cash check images. All right, we've provided every day, as you know, as I currently speak, we see about 50 checks getting cleared out of our out of our account, and it's a manual process. All right, I have to go through the online banking. All right, click on view check, then convert it to PDF. That's the only way. That's the only receipt. But to actually because they went to, it was mailed to the customer through stamped envelope. There's no way you can get a receipt for a stamped envelope.
So, Mr. Edigwe, we basically then take you at your word that these checks were mailed.
We have the evidence of the check being cashed, and my attorney, I believe, staff, and the PSC staff do have that.
And it's your testimony that 334 checks have been cashed as of today?
As of the 25th. We've not updated what took place on the 26th.
How do you respond to Mr. O'Loughlin's assertion that based on these approximately 1,200 customers, the average check is only about $53, and your rate that you would charge was somewhere between 13 and 19 cents per kilowatt hour? That number does seem relatively low. $66,000 for these 1,258 customers. How do you respond to his allegation?
It's based on the customer's usage. We cannot control the usage of the customer. All right, some customers are using thousands of 1,000 plus kilowatt hour a month. Some were just using as low as 20 kilowatt hour. So it's based on the customer's usage. That's beyond our control. That's why the re-rate calculation for each customer was done, and the evidence was issued to both staff and OPC to verify that.
And when you say evidence, are you referring to the master Excel spreadsheet that was filed on November 6th?
Correct, yes.
And Your Honor, if I may, there's the master spreadsheet, and there was also a flash drive given that had an individual Excel spreadsheet for every single one of those customers.
Thank you, counsel. We do have both of those documents. Mr. Edigwe, how do you respond to Mr. O'Loughlin's claim that their very brief spot check of approximately 30 customers turned up a number of errors?
That's totally wrong. All right, that's totally wrong because that's totally wrong. From the email I got from my attorney, all right, they were asked, if it's in regards to names, that's totally wrong. It's only one customer. All right, there was only one customer whereby the re-rate calculation of just gas instead of the re-rate calculation was only done for our gas account mistakenly. So the agent working on our account in doing the re-rate calculation forgot to include the electric re-rate calculation, which I testified to and got that fixed, and the check has been mailed as well, and the image of the check has been uploaded for both staff and OPC through the Dropbox.
Mr. Edigwe, so you do see that OPC has detected at least one error. Is that right?
One error, yes, I agree with that. Yes.
So Mr. O'Loughlin is not totally wrong. Is that correct?
I don't know where you got, as much as 30.
Was there any quality control in your process in terms of having your staff double check the math along the way?
Yes, there was. Yes, there was, but I don't know how Ida Wilson, which is the only customer that was re-rated for just gas and our electric was not re-rated, how it skipped through the cracks, basically.
My question was, can you explain the quality control measures that were undertaken by Sunsea Energy?
When the re-rate calculation is done, all right, on the Excel, which we provided to both staff and OPC, I also had somebody else look at the calculation so as to make sure it's correct.
Who was the somebody else?
Another, another person in charge of as part of my accounting team.
And who was that?
His name?
Yes.
Joy Fawcett.
Can you please spell the name?
Joy, J-O-Y, Fawcett, F-A-U-S-A-T.
And is she a Sunsea employee based in Cherry Hill?
Yes, she is.
Mr. Digway, I have one final line of questioning for you based on the testimony you filed last week. Is it your hope and intent to continue to do business in the state of Maryland?
Yes, it's my hope. I just want to start on a clean slate and, and make sure everything is, being done legally and compliantly right. That's it.
You stated that, and these are your words in your testimony from last week, that the only marketing materials that will be used in Maryland is the attached flyer, this flyer. Is that correct?
Yeah, that was to generate inbound call, yes?
To generate inbound calls. Can you elaborate?
If you see there's a contact number there, all right, we do a mass mail, to generate inbound call, but we're not, as I said, we will not be doing any further, telephonic based sale in the state. So that would probably not be used at all. It's strictly face-to-face, door-to-door sales. All right, to generate inbound call, we mail that flyer, to a mail list, which we have a mail list company which we give the project to. Oh, can you guys mail this flyer to to a specified mail list, and that's how we go about generating inbound call.
Are you sending this flyer to potential customers in the state of Maryland?
Not right now, no. And we would not be using that. We won't use that at all anymore, because if we retain our license in the state, we don't plan doing anything telephonic in the state.
I recall at your testimony on October 7th, you stated that you were a marketing guy. That was your quote. Do you remember that, Mr. Digway?
Yeah, I came from the marketing industry, yes.
Do you consider yourself an energy guy as well?
Yes.
I want to talk about this document, which you marked as Exhibit JA1 for just a moment.
Go ahead.
There's a number of typos. It doesn't refer to your Sunsea Energy website. It refers to the rewards website. But at the very top, the marketing flyer states that we provide 100% renewable energy for your electric and gas. We provided monthly variable rate. Tell me about the renewable natural gas product.
All right, tell you about the renewable gas products. All right. That's a question for my okay. I'm aware whatever we use on gas, I do believe I know on the electric side, but on the gas side we purchase. I can't recall if we purchase RECs for the gas. So that's something my team will answer.
You just stated you were an energy guy, correct?
Yeah, I do believe we purchase RECs for the gas as well, if it's required in the state.
You don't know if you purchase RECs for natural gas, do you?
Not by heart, no.
Your marketing flyer has the logos of Calvin Klein, Ruby Tuesday, Subway, Nike, Westin Hotels.
Mm-hmm. Rewards.
You do not have permission by any of these corporations to be using their logos on your marketing flyer that you state will be the only material that will be used. Isn't that true?
If they go to sunseaenergy.com, they are able to shop with, get points with their reward dollar in spending, in purchasing anything that they want, that is accessible through the site. There's a specific site that shows them everything. So
Mr. Digwe, my question was the company names and the trademarks that you provide prominently on your flyer.
It's also on our website.
Okay. Do you have permission from Westin Hotels to be using their trademark?
They can use Sunsea Energy points with Westin Hotels.
I am asking you, do you have permission by Westin or by Calvin Klein to be using their trademark to advertise Sunsea Energy?
Directly, no.
No. This is what you filed with the commission last week, sir. It has nothing to do with the energy product that you're trying to sell. I'm not even sure what renewable natural gas is. This marketing material, which is your only exhibit, is rife with typographical errors, directs the customer to the wrong website, prominently displays that you're offering the $25 in rewards to over 330,000 local deals. I'm not sure what a local deal is.
Our reward provider, all right, we have a rewards provider that gives us access. They get paid every month for whatever our customer use by Sunsea Energy. All right, so our reward provider provides all those packages. That's all I can say. And the flyer that says you can go to Sunsea Energy Rewards, to redeem whatever you're they're entitled to.
My point, Mr. Digwe, is you're not marketing energy with this flyer, which you say is your sole marketing tool going forward, correct?
For telephonic inbound based sales, yes, that's what we use in generating inbound calls.
I hope, Mr. Digwe, that you do not use this flyer in the state of Maryland or any of the 4 other states that you operate in.
Okay.
This is sloppily put together. It doesn't have anything to do with electric or natural gas retail supply. In my opinion, it inaccurately fools the customers into believing that you're associated with all of these nationally known, recognized brands. I'm surprised your attorney even let you file this, to be quite honest. Okay, thank you, Mr. Digwe, for coming today. Did you have anything final to respond to?
In regards to the flyer, all right, we have we have a contract with our reward provider. All right, in regards to if any customer who seek our that have our services, that's one of the benefits. They can go to Sunsea Energy Reward. Every month, points get added into the account. Reward dollar gets added into the account, and they can use it to shop for shop and get Amazon gift card, whatever they want. That's that is accessible on that site. I personally directly don't know what the customer gets, but I know a lot of our customer currently benefits using the Sunsea Energy Reward platform, which was a site built by our reward provider. So we don't necessarily have a direct contract with Marriott or Sony or Subway and so on, but our reward provider does, because that's the only way we know a lot of our thousands of our customers benefited from it, and that's it.
One final question, Mr. Adigwe. The customers in Maryland who you involuntarily returned to default distribution service, did they keep their rewards points or did they lose their rewards points?
From the day their service end flow with us, they still have access to their reward points. Yes, they still do.
Thank you. I have no further questions for any of the witness or counsels. I'll turn to my colleagues at this point, and I appreciate the indulgence.
All right. Thank you very much.
Stay with us, Mr. Adigwe. We'll have more questions, I believe. Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Adigwe, the flyer that the chairman was questioning you about, FA1, that you filed, you're not going to use that anymore in Maryland. Did I hear you say that? You don't intend to use that to generate inbound calls?
Correct, yes.
So if that's no longer going to be your business model, what is your business model going to be in Maryland going forward?
For marketing?
Business model. If you're going to generate inbound calls with that little piece of work the chairman was talking about,
correct.
What are you going to do to get customers? How are you going to solicit your customers?
Through door-to-door only. Door-to-door, we intend to give out door-to-door contracts to door-to-door firms in the state of Maryland.
And
to generate.
If you only have one piece of marketing material, what marketing material will you be using, should you be fortunate enough to keep your license in the state of Maryland, to do this door-to-door solicitation?
It's currently under development, and when it's fully developed, I'll release that to the to my council to submit to the commissioners.
All right, one more question about the checks. When did you start acquiring customers? When was your first customer brought on board?
I would say roughly September, October of 2019.
So we're led to believe that the average refund check to 1,200 customers over that period that accumulated was $53. That just seems to me, considering the rate disparity between SOS and what you are actually charging customers, seems at first blush exceedingly low. Would you have a problem with an independent audit of your calculations as suggested by the Office of People's Counsel?
I don't have a problem with that, but I don't have a problem with that. But the re-rate calculation that was done, they have the evidence. They can actually submit that to, if it's possible, they can submit that to the utility, to check the historical usage of the customer. It's there. It's, the utility have access to this information as well.
Yeah, I'm just concerned with the accuracy of the calculations, and you have a vested interest, maybe, and maybe are not objective in these calculations, and they ought to be audited to verify such independence and veracity.
And to be frank with you, it's not like, the only mistake was the customer was meant to get 2 re-rate done, one for electric and one for gas. All right, and it was only done for the gas account, and they forgot to do it for the electric account. So it's not a problem of the actual re-rate calculation. It was a problem. It was a problem of a customer. They forgot to do the re-rate calculation for his electricity. That's all.
Yeah, you're referring to one customer. I'm referring to an audit of all customer refund calculations. I don't want, I'm not suggesting an audit of one customer. You're saying take our word for it. We did it right. And I'm having a hard time with that. I'm struggling as a commissioner with taking your word for it for a lot of different reasons, sir.
I totally understand, but we provided a rate calculation for each of those customers, and I have, both the OPC and staff can easily verify. They can actually verify that from the through the utility. Because if it's the information we get from the utility, that's what we used in doing those re-rate calculation. We need just manufacture number offhand and just put numbers together.
Could I ask staff, Mr. Wilson, you or your witness, if staff has a position on OPC's suggestion for an independent audit on these re-rate calculations?
Yes, Your Honor, we would support that.
Okay, very good. Thank you, Mr. Chairman. That's all the questions I'm going to ask today, I think.
Commissioners, Commissioner Herman.
Sorry, can you hear me?
Yes, I can.
Okay, thank you. Mr. Adigwe, can you tell me when Sunsea returned the door-to-door customers that it had back to standard offer service?
November 2020. November 2020.
November of 2020.
Yeah.
Okay. And did you seek to get the customer's approval to do that, or did you just do that unilaterally?
We reach out to the we reach out to the customers, but some we could not get in touch with them. All right, so attrition already. It was just only a few customers left, and attrition already ate up most of the customers since we could not market in the States. We stopped marketing in the States since May. All right, so it was only a little bit of customer left, and we just had to let them go.
Okay, so how did you reach out to them?
By telephone call.
By telephone call. And how many of them were there that you had left? If you know.
That we had left as of before returning them back to SOS?
Yes.
About 300.
About 300.
Yes.
And did you maintain a record of your contact with these 300 customers? And
No, we could not.
Just let me finish.
Go ahead.
Let me finish.
Mm-hmm.
Did you maintain any kind of record about returning these 300 customers and how many you reached and how many you did not reach?
No, we did not maintain any record. We did not maintain any record of how many customers we successfully reached and how many we didn't reach.
Okay. Thank you very much. Thank you, Mr. Chairman. I think that's all I had. Thank you.
Any additional questions? Seeing Commissioner Pritchard.
Yeah, just one question. I think a lot of questions have already been thoroughly asked. But I did want to give Mr. Adigwe the chance to just respond to the staff concerned that their advertising about competitive rates is deceptive. How would you respond? Do you think you're not, or do you think you are being competitive with other suppliers?
We are being competitive with other suppliers, yes. All right, so I think that's using the word competitive rates is not, we are not being deceptive. No, I totally disagree with that on what ground.
Well, the staff pointed out that you're at the very, very high end, if not exceeding all the other suppliers in the rates you're proposing to charge. So how is that competitive, and how is it not deceptive to claim that you're being competitive?
Now, I don't really track any of my competitors, rates. All right, I don't really track that, but in terms of how we generate our pricing, I know we are being competitive. Now let me go over the historic. Right now on the site, I want to locate the historical rate. Where is it again? Give me a second. 1 second. Historical rates. Let's get again. I have to look it up tonight. Except I'm trying to.
I'm going to stop the witness from doing whatever research he's doing.
Yeah, that's fine, Mr. Chairman. I don't need to pursue this any further. I mean, I think I heard him say he doesn't track his competitors, so I'm really not sure how he would determine whether he's competitive or not. So anyway, thank you, Mr. Chairman. No further questions.
Thank you, Commissioner. I believe the witness says he doesn't track his competitors' rates, but he knows that he's competitive. Commissioner O'Donnell.
Thank you. I'm sorry I didn't see Commissioner Linton had unmuted. But I did have a follow-up, if it's okay, Commissioner Linton, to Commissioner Herman's question for Mr. Adigwe. Mr. Adigwe, you said in November of 2020, you just decided to give up 300 customers because you wanted a clean slate, I think you said. Did you have signed contracts for those 300 customers you just dumped back onto SOS that were acquired through door-to-door solicitations? Did you have the required statutory, COMAR required signed contract for those 300 customers?
Yes, we did.
And that could be produced if it was requested.
Yes.
Okay. And that was 100% compliance?
Yes, that was 100% compliance. We had no, PUC complaint, anything. But
yeah, I'm trying to figure out why your company just decided to drop 300 legally acquired, good-paying customers. I'm at a loss. Can you help me understand that a little bit better?
It was an internal decision, basically.
Let me ask you this way. Did you find any other compliance issues with those 300 customers that caused you to decide to drop them off of your rolls, off of your books, and back onto SOS? Anything whatsoever, sir?
They were being chewed up mostly by none. No, we didn't have any issue on the compliance and when it came to our door-to-door sale. Now, since we could not market in the state, And due to the, actually in the first place, and it's the pandemic that made us expound our, telemarketing in the States because of our book, the little bit of business that we had in the States was being chewed up due to attrition. Attrition is very aggressive in any deregulated states. And if you can't market and, attrition is eating your book day by day, and it's sometimes just not worth it.
Yeah, but I hear you talking about attrition of your customer base, but then I think I also heard you said you dropped 300 customers back onto SOS. You tried to contact some of them. You didn't keep a record of contacting some of them or any of them, but it wasn't attrition. You dropped them back onto SOS. And I'm trying to figure out why you would do that. If they're paying their bills, you got money coming in, and you just out of the goodness of your heart decided to, with all these other troubles that you have with compliance, decide to send those 300 customers back to SOS to the utility? I don't get it. Something's not ringing right here. You weren't ordered to do that.
Yes, we were in order to do that. It was an internal decision. We were losing all our investments in the state. Those costs, we were losing our investments in the state. All right. Attrition was basically hitting the book. We just like to start all over again in this state, and if it's possible, that's it. All right.
Yeah, I know I guess that's why I'm having a hard time understanding. There were no flaws with customers. You were going to you want to start all over, but you want to start with 0 customers instead of 300 legally acquired customers. And there's something that's like not computing with that kind of line of thinking, but I'll drop it there. Thank you, Mr. Chairman, for my follow-up. I appreciate it.
Thank you very much, sir.
Commissioner Linton.
Thank you, Mr. Chairman. I had a question for the staff witness, Mr. Mosier, regarding his filed testimony on page 4 regarding the recommendation of civil penalty. We didn't see filed testimony from People's Counsel, but through their counsel, it's my understanding that they're recommending a different civil penalty than the staff. So could you help me to understand? I understand the rationale, the justification that the staff is raising for why there should be a civil penalty. But there's a difference of amount recommended by 2 parties. So I'd like to understand why staff recommends $500,000 versus what the People's Counsel recommends.
For staff, for me, the civil penalty is always, for a lot of these supplier complaint cases, that's a really difficult number for me to come up with. And I think with this one, I look back to what the commission did in, I believe it was Smart One Energy, where it was a fine of, I think, $547,000. And this seemed like the actions were in the ballpark of that there were serious violations and numerous serious violations.
Okay, I'm sorry.
Yeah, so basically just kind of trying to follow commission precedent with a civil penalty.
Okay, what is your, well, let me ask for Mr. Laughlin, the People's Counsel, am I correct that you recommended a different civil penalty than the one recommended by staff? Okay, so I believe you said earlier it was $2.5 million. Is that still accurate?
That is accurate.
Okay, so Mr. Mosier, what is your response to the People's Counsel's recommendation? It's 5 times higher than yours. So
I certainly would not object to that amount. Again, I feel a certain, I feel like I'm somewhat bound by commission precedent, but there was also a case several years ago against a supplier where staff had some alternative recommendations, but one of them was for a fine of $3.5 million.
Okay, so kind of going back and forth between witnesses here.
I certainly don't object to this, to the OPC.
So to Mr. O'Loughlin, then your recommendation is, the staff's recommendation is a fifth of your recommendation. So what's, could you, I understand what the rationale would be in the justification. What's your response to the calculation from staff's perspective?
OPC is of the belief that staff's recommendation is too low. When you look at the statute, each violation can be subject to a $10,000 fine, and each separate day is its own violation. And if I recall correctly, and I was looking at the transcript yesterday, we saw something around, I want to say 1,400 different violation days, and then another set of 1,000 violations for each telephonically solicited customer, and also failure to provide them with a copy of a contract summary following enrollment. So when we did all the back of the envelope math, we figured that maybe $1,000 per violation was justifiable, and that totaled us up to about $2.5 million.
Okay. Thank you, Mr. O'Loughlin and Mr. Mosier. And thanks, Mr. Chairman. I have no further questions.
Thank you, commissioners. Based on the testimony that was entered into the record this morning, and based on the additional oral testimony that we received from both counsel and the witnesses, I do believe that there is cause for concern with respect to the accuracy of the refunds that were issued, in addition to other areas of concern that were raised. Just doing some rough math, if the re-rate was a difference of a nickel per kWh, and in Sunsea's case, it may very well be in excess of 5 cents. And assuming an average customer uses approximately 500 kilowatt hours per month, that would, rough math would say that's a credit of about $25 per month. One customer at that rate would be $300 a year on average. And with approximately well over 1,000 customers, that would be a minimum of $300,000 in refunds. So I find the $66,000 refund amount suspect. I was pleased to hear that Mr. Adigwe, on behalf of Sunsea, would not object to an audit, the audit that is being recommended by Office of People's Counsel and supported by staff. At this time, since it's unclear whether or not Sunsea Energy LLC has fully complied with the Commission's directives of October 7th and October 9th, 2020, I am going to make a motion to my fellow commissioners that we go forward and accept the audit requirement of Sunsea with respect to whether or not the company complied with our directives regarding the refunds.
If I may, for just a moment, if that'd be all right.
Yes.
One thing I wanted to bring up that I failed to mention in my opening, and I apologize for that, is one of the issues in discovery that we were requesting was copies of signed contracts for the door-to-door solicited customers. And Commissioner O'Donnell brought this point up as well, inquiring whether there were any issues with the 300 that were dropped. One of the things that we wanted to look into, and since we just got those signed, a batch of those signed contracts this morning and haven't been able to fully review, is to take a look to see whether there are discrepancies in those door-to-door solicitations as well. And so looking at the possibility of an audit, if the audit could include reviewing to see whether they have signed contracts for each of those door-to-door solicited customers, and to verify that those customers were appropriately enrolled as well.
Mr. O'Loughlin, is the scope of that customer base that you're referring to the 300 customers that were dropped in November of 2020?
The scope that we were looking at was all of their door-to-door solicited customers.
Okay, counsel for Sunsea.
Yeah, sure, Your Honor. A couple misstatements. First, what was asked in discovery and what the commission ordered was a discovery response to a question that asked for a list of names and addresses of door-to-door customers from November of 2019 to January of 2020. So that's all it asked for. It didn't ask for actual contracts. So there are no contracts that are produced, and it's not for every single door-to-door customer enrolled. It was just for that 3-month period. So that's been responded to and provided.
That is correct. What we were looking to do from there was to ask for contracts for a small sample so that we weren't overwhelming ourselves with paperwork, but rather just some sort of check similar to what I was able to do with the 30 customers for which we had CAD complaints to verify their refund amounts.
The witness for Sunseed clearly opened the door with respect to questions regarding these door-to-door contracts, and it appears on its face that there's additional violations in returning these 300 customers that were mentioned by Commissioner O'Donnell to SOS service without prior notice in some cases, which would be in violation of the contract between the customer and Sunsea Energy. Mr. O'Loughlin, can you clearly state for me what you're requesting? Are you requesting that this be made a part of the audit, or are you requesting that Sunsea provide you directly with some of these door-to-door contracts or all of them?
At this point, I think the most expedient thing to do is to make this part of the audit.
And how would you make it part of the audit?
Have the independent auditor review each contract, make sure that there's a signature from each customer on that contract, and we can go from there.
And the scope, Mr. O'Loughlin, would it be every door-to-door contract that has been signed by customers of Sunsea going back to day one, or something more limited?
Yes, Your Honor, going back to day one, I have a hard time accepting that there's been compliance on either end, whether telephonically solicited or door-to-door.
We did hear a statement from the witness for Sunsea claiming that he was in full compliance with all door-to-door contract requirements under COMAR. Notwithstanding, I am concerned with the practices of this company, and I believe that it is warranted to grant Office of People's Counsel's request to have the audit expanded to review every door-to-door contract that was entered into during the period in which Sunsea Energy LLC was a licensee of this state. I'm going to propose two motions. Reflecting the scope of any potential audit. I believe it needs to be an independent auditor based in Maryland. I believe that the selection of the auditor should have the input of both staff and Office of People's Counsel in determining that audit. I don't believe it's necessary for the commission to get involved with the approval of the audit. It will take some time for the parties to agree on the selection of an independent auditor or accounting firm to perform this. It may be substantial. So I'm going to propose that the parties have 3 weeks in which to identify an independent auditor and have staff file with us in 3 weeks the identity of that auditor. So just a short filing, Mr. Wilson, if the motion passes or majority support is received by the commissioners. 3 weeks would be February the 16th. And I honestly don't know how long an audit of this scope will take, but I will propose with a motion that the audit report be filed on April 1st of 2021. That would give the auditor 5 or 6 weeks. Of course, if more time is necessary, I would ask that the parties file a motion seeking more time to allow the full completion of the audit. During that time, of course, the moratorium on solicitation, marketing, and enrollment of new customers in the state of Maryland will continue. So it is in the interest of at least Sunsea Energy to get this audit wrapped up as quickly as possible. Before I formalize this with a motion, I'll ask the parties if they have any questions, and then I'll ask my commissioners if they have any concerns with my motion.
No questions from staff.
No questions right now. Thank you.
Questions here.
And from my fellow commissioners? Seeing none, I would move that the commission order Sunsea Energy LLC at its own expense to work with Office of People's Counsel and Commission Staff Counsel in identifying a Maryland-based independent auditor to conduct a full report on Sunsea's compliance with the refund directive that was ordered by the Commission on October 7th, 2020, to determine the accuracy of the refunds directed to customers by the Commission. Additionally, the scope of the audit will include review of all door-to-door contracts executed by Sunsea customers in the state of Maryland since Sunsea Energy LLC was licensed to do business supplying both electric and natural gas services to ensure full compliance with state law and regulations. The vote begins with Commissioner Herman.
Aye.
Commissioner Clinton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. And let me be clear, the date for the filing by staff revealing the identity of the independent auditor is due on February 16th. The audit report is due on April 1st, 2021, barring any motion for an extension in time. Mr. McGee, do you have?
Yeah, I do, Your Honor. So when you stated the motion, something came to mind. So an audit of numbers that can be done by a certain qualified individual to see are numbers produced correctly and added correctly. The second part of the audit is about, is there legal compliance with a contract? And that's a different professional that would figure out the law and if there's compliance. So I didn't see that distinction until you stated the full motion. I don't know if there's an amendment to the motion that could be made that maybe two different auditors can be used, or how we deal with these. Sounds like two different sets of skills this auditor would have to have.
Any audit firm, particularly a large audit firm, will have a team of auditors assigned to this. I'm not assuming that you're going to be approaching a CPA who does income taxes for people. So whether the audit report be the product of a single auditor or two independent auditors, which I imagine would only increase the cost for your client, the commission has no opinion of. However, if Sunsea seeks to engage two separate independent Maryland-based auditors, you would need agreement from Office of People's Counsel as well as Staff Counsel for the selection of that auditor as well.
Okay, thank you.
We did not touch on the amount of any penalty, with the exception of the exchange between Commissioner Linton and Counsel for Staff and OPC. At this time, I believe it would be premature to have a discussion on the assessment of a penalty on Sunsea Energy, if any, until we receive the results of the audit report or audit reports, depending on if the parties elect to retain two separate auditors. And the commission, once we have an opportunity to review the audit report, will issue subsequent notice in docket 9647 to establish another hearing. Are there any additional questions from the parties and or the commissioners? Seeing none, today's status conference is now adjourned. Thank you.
Thank you.
Off the record.
Off the record.